Well, for a number of years I'd actually been really interested in coming to HKU, and I think the main reason were a couple of colleagues who are here, Professor Marco Wan and Professor Scott Veach, who are some of the leading figures within the fields of research that I work in, law and literature, jurisprudence. So the opportunity to be able to come and work with them was really one of the leading reasons for wanting to join HKU, as well as a number of other colleagues here too. As well as the people, I think just the research environment at HKU for me is really sort of unparalleled. The actual funding for research here, the support for research is a real thing, right? So they really try and get a balance, I think, between teaching and research, which is quite rare in a lot of universities in the world, that you actually have time to do the research as well as the teaching side. So that the way in which HKU and Hong Kong generally takes research seriously, puts the funding aside for it, as well as the time, that was obviously really attractive for someone who is a research-intensive scholar. The teaching environment too is fantastic. Small class sizes, amazing students we can talk about, and the city. The city is it's a vibrant, exciting city. There's so many layers to it. It's such an exciting place, and to be in this part of the world, to be in Asia is really exciting. And I'm coming from Australia, so it's much more difficult to get from Australia to other parts of the world. Hong Kong is much more sort of centrally located. So to be able to connect with different collaborators in different countries, So all these different things I think really helped. So I'm trained across a couple of different disciplines. So within law, the humanities, and the social sciences, I completed a Bachelor of Laws and a Bachelor of International Studies at the University of Adelaide in South Australia. So following that, when I completed those degrees, completed my legal studies, I practiced for a little bit with the Crown Solicitor's Office, the government lawyers in South Australia, for about a year, before moving to Canada, actually, to do a Master of Laws, a Master of Comparative Laws, at McGill University in Canada, which was, for me, a turning point. It really exposed me to a lot of exciting research, a lot of exciting ways of thinking about law, different questions that you can pursue within legal studies. And that was, I think, the turning point for me academically. It encouraged me to pursue a PhD, which I did in Australia, at the Australian National University. Not in a law school, it was in the School of Regulation and Global Governance, which is a very sort of vibrant, interdisciplinary research school, brings together lawyers, sociologists, psychologists, architecture scholars, in thinking about questions of regulation and global governance, which is also of relevance to my research. So I did my PhD there for about 4 years. I was interested in the field of international development, when different agencies, organizations such as the United Nations, implement projects to build the rule of law after conflict in countries around the world. I was interested in what happens when these projects are rolled out on the ground, when someone like the United Nations, in collaboration with different government agencies, try to build a legal system in a country after a violent conflict, after a period of civil war. What does that actually look like? What does that mean to build a legal system, to build the rule of law? And for me, importantly, what does that mean in relation to the existing legal systems or laws that are already there on the ground in that country? And I looked at Liberia in West Africa. It had experienced many years of civil war, civil conflict. The institutions of the state, the legal system had been decimated, and there'd been about a 10-year post-conflict, so peace-building, rule of law development period, so 10 years of the United Nations and different partners trying to build the legal system there. And so I went to Liberia to see what that actually meant on the ground, what had happened over those 10 years, and how did that interact with, how was it shaped by, how was it shaping the plurality of laws that were already in West Africa, in a country, not in West Africa, in Liberia, in a country that has 30-odd language groups and a vast plurality of legal systems already there. So that was my PhD. After that, I went to Melbourne Law School, where I undertook a postdoctoral research project for a number of years, looking more at more of a legal history of the colonization of Australia. So turning back to Australia and trying to understand British colonization of Australia in the 19th century with different questions of law around property, around human rights, around sovereignty. And then following that, I went to Adelaide, as you mentioned, Adelaide Law School for a couple of years, where I taught property law and legal theory as well. Wonderfully welcoming, absolutely wonderfully welcoming, yeah. So I've been here about 6 months now. In the first couple of weeks, it was a flurry of warm welcomes and dinners and lunches, which was wonderful to meet colleagues. So yeah, absolutely, the hospitality was fantastic. So I've been here 6 months, but it was mostly teaching. I front-loaded all my teaching. I was teaching a couple of new subjects for me. One was the law of torts. So the law of torts, new to me in recent times anyway, but really, really interesting subject, really to do with the relationships between people in society, the obligations that we owe to each other in terms of care for each other within society. I was teaching negligence in particular. So that was a wonderful opportunity to engage with a lot of students, but also legal theory. I ran a number of tutorials in legal theory, so that was a chance to be in the classroom with some of the students and engage in really enriching conversations. So absolutely wonderful 6 months so far, and I'm looking forward to the next. So my interaction mostly has been with undergraduate at this point in these 6 months, and look, absolute pleasure to teach. They are exceptional students, absolutely exceptional students, which is not surprising, I think. But the levels of preparation, the seriousness with which they take their studies, when they come to class, they come prepared, and with a little bit of pushing, I think, a little bit of facilitation, they can enter into some really, really wonderful conversations. My experience is mostly legal theory, jurisprudence, so questions of law and politics and society, thinking about law in context, if you like. And so I learned a lot from them about Hong Kong, being new to Hong Kong, and the legal system in Hong Kong. But just, a real pleasure to be able to engage with them in the classroom. Demanding as well, very demanding, which puts a lot of responsibility on you as a teacher, but yeah, absolute pleasure. So it's a really important point, I think, in an academic career. Certainly for me, my master's at McGill in Canada was a turning point. So it was the point that sort of pivoted me towards becoming an academic, to pursuing a PhD and then taking it from there. So why is that? I mean, the advice I'd give if you're considering a master's in law or any other area, it's a really valuable opportunity to undertake that slow, careful, deep research, which you otherwise don't get a chance to do usually as an undergraduate student, which is more about taking on a number of courses, a large number of courses, at a quite sort of shallow survey level, generally in an undergraduate degree. So the LLM is that first opportunity, and it was for me, to undertake that slow research, that deep, careful research, and to do it under the supervision of someone who hopefully will be in your field or future fields, who can expose you to literature that you may not otherwise be exposed to. So if you're thinking about an academic career, if you're thinking about a PhD, the LLM is the chance to think about what that actually means in a shorter program. It's usually a year or two commitment. But I think also if you're not thinking of becoming an academic, if you are thinking of pursuing other practical professional areas, that it's still really valuable for the skills you get, being able to really undertake that careful, slow, long research is. Yeah, so my research, it crosses a number of different areas. As I mentioned before, my work is really interdisciplinary across sort of law, the humanities, as well as social sciences. But the fields in which I work really could be called law and colonialism would be one area. Law and literature, or law and humanities more generally, so law and literature, law and art is another field that I work within. Critical legal theory as well, so law through different critical theoretical traditions, jurisprudence, for example. I've also worked previously, so my PhD, as well as some of my post-PhD research, was in this field of law and development, or law and international development. So quite sort of disparate across those different fields. But I think what holds them all together for me, or what interests me about these different fields, whether the focus is on 19th century British colonialism or international development in the 21st century, I'm really interested in this question of law, art, and politics, how law, art, and politics intersect in these different fields. So to give you an example, a question that I'm thinking about right now for a new project that I'm working on is what sustained the authority of colonial law, of British colonial law, in Hong Kong, in the Straits settlements, Singapore, Malaysia, as you'd call them today. So what sustained the authority of colonial law in these British colonies? Now, there'll be a number of different answers to that question of what sustains the authority of law, but the answer that I'm interested in is really art, right? Art could be literary, could be visual artworks, could be other forms of art. And the reason really is, like, when you think about, so there's a lot of work that's been done in this area looking at the relationship between law, art, and politics. If you've been into a courtroom and you've walked in and you've looked around, you'll see the way that the courtroom is set up, the architecture. You'll see the pictures on the walls, these portraits of important people in their gowns and wigs. You'll see the judge at the front. I don't know about Hong Kong, but certainly in Australia, they'll be wearing the gown, they'll be wearing the wig. The barristers at the front will be also wearing similar sort of outfits, similar sort of costumes. As you enter the courtroom, you'll bow to the court, you'll very quietly take your seat. So there are all these mannerisms, rituals, as well as the aesthetics of the courtroom itself, the way it's set out, which is doing a lot of work, a lot of legal work. And that work has to do, in part, with the authority of law itself. So if the question is, where does the common law in Hong Kong or in Australia, where I'm no more, if the question is, where does the law get its authority? Well, a lot of it is from the aesthetics, is from these rituals, decorations, clothes, architecture. It is doing a lot of that work. And if you just think about it, if you took a legal trial, if you took a court process and you took it out of the courtroom and you put it in a pub or in a nightclub or some other place that has a very different atmosphere, what sort of authority would the legal process have, right? If the judge is sitting at a table with a pint of beer, passing judgment, what sort of authority would that judgment have? It would be very different to the courtroom. So anyway, a lot of the work understands that there is this really important relationship between aesthetics or art and law, and particularly the authority of law. And it's that question, I think, that I pursue into a lot of my different research. So whether it's to do with colonialism in the 19th century, so again, when I'm trying to think about what sustained colonial law in Hong Kong, I'd be interested in looking at the ways in which different representations, different literary discourses were supporting, maintaining, sustaining that authority, right? And then on the flip side, the way in which if local people, the subjects of the colony, the ways in which if they were to resist the colonial law or counter the colonial law, the way in which that can play out through artwork as well. The way in which art can be sort of a tool or a way of, not a tool so much as a way of engaging with the authority of law and undermining that authority, right? Putting forward different modes of authority, different laws as well through artwork. So it can be both a form of colonizing as well as a way of resisting colonization or decolonizing as well. So these are the kinds of questions that really interest me in my work. Yeah, so I've got a forthcoming book which I could talk about. So this is coming out of the project which I worked on in Melbourne in Australia on the colonization of Australia. In part, it's a legal history of the British colonization of Australia in the 19th century, particularly in the southeast parts of Australia. So in part, it's sort of a conventional legal history that focuses on how British understandings of property, of dignity, of sovereignty, how these different understandings work to dispossess, dehumanize, disempower Indigenous peoples, First Nations peoples in Australia. So in part it is contributing to a body of work which is quite a conventional sort of legal history, drawing out these different understandings and how they worked to dispossess Indigenous peoples. But in part, I'm also doing it as a law and literature project. So I'm using a concept of laughter, which is coming out of a Russian literary theorist, Mikhail Bakhtin, his concept of laughter, the carnivalesque. I'm using this concept in order to critique and, I guess, undermine these British colonial understandings of property, of dignity, of sovereignty. So laughter, in this understanding, is a critical, it offers a critical tool or a critical theoretical concept that really undermines, unsettles, critiques these understandings. But what's really interesting, I find, with Bakhtin's understanding of laughter is it's not only critical, it's also very regenerative. So it opens up new possibilities for new understandings to emerge. So it's not only sort of trying to destroy or undermine British authority and the authority of their laws, but it's also opening up a space to have new understandings sort of come through as well. So in part it's a law and literature project using these sort of literary concepts around laughter, around the carnivalesque. And in part it's a legal history as well. So that's a book that I'm currently working on, in the process of developing, of writing, as one example. It's a good question. So in our field in law, research is mostly individual. For me at least, and I think for many of my colleagues, it is mostly individual. You spend most of your time reading and writing in a quite isolated way. But at the same time, it is highly collaborative in sort of maybe counterintuitive ways. So the collaboration for me usually comes through in the shape of what could be simply encounters with your colleagues over lunch, conversations over lunch, or more formalized ways like reading groups, certainly seminars, workshops, conferences. So these spaces, while they're not sort of a laboratory in which you're sitting down and working on the same project with colleagues, nonetheless they're collaborative in the sense that a lot of those conversations are really provide, I think, the ideas, the inspiration for the kind of individual work that I do and that we generally do as scholars. So there is an interesting, I think, relationship between the individual nature of the research that I do and the collaborative side. I mean, I also do collaborative projects which are more conventionally collaborative, so writing with a colleague or a friend, so collaborative writing projects which are really interesting to engage in, the way in which you can learn about writing by writing with someone else. And organizing events together, organizing workshops together in these more formalized settings. But it's really, I think that side of it is really important, really enriching, and it is something that young scholars should see as a very valuable part of what it means to be a scholar. Absolutely. So a mentor of mine once gave me some advice on publishing, and I think for me it is really important. I think it's helpful to think about. So the mentor said, look, think about publication not as the final word, but as just contributing to an ongoing conversation. So when you write an essay, when you write an article and you publish that journal article, it can be paralyzing to think of that as the final word on the topic, as your magnum opus, the last thing you want to say about it. That can be paralyzing, and it can be very difficult. You can slip into perfectionism, and it might become unproductive. If you see it more as, I think, being part of an ongoing conversation, then it's more liberating for me because you can change your mind later. It doesn't have to be the last thing I have to say about this topic. It also doesn't have to be my most developed idea about this topic. It allows me to write something again on that topic in a few years' time when I have thought more about it. I might have changed my mind. So I think it's liberating. It's also maybe more honest to what publication is. It's a dialogical process. You put out a publication to an audience in order to invite a kind of conversation with them, to engage in a conversation with them, and to see that as an ongoing conversation allows you to see your own work as just part of that process and not, like the trump, the final word, and that's it, right? So yeah, so that would be one piece of advice I'd pass on. Answer to both. How do I spend my weekend? And releasing pressure is rock climbing. So I enjoy rock climbing. I enjoy outdoors generally, but rock climbing is the thing I do most of the time when I'm outdoors, along with hiking and sort of, And Hong Kong is, this is another amazing thing about Hong Kong, right? Is the spaces, the green spaces, the mountains that are here is just absolutely fantastic and so close to the city. So I'd committed to coming to Hong Kong already, but then I was looking into the kinds of rock climbing that's available, and Hong Kong is full of rock. Like, it is absolutely fantastic place to be able to engage in that pastime. So yeah, I find that very, it releases pressure as well as just a nice way to see Hong Kong from different angles too, in a way, because some of these climbs that you do are actually looking out over Kowloon, looking out over Central, so you get these spectacular views of, these iconic views of Hong Kong when you're halfway up one of the peaks, right? So it's really, really interesting experience here. So 3 books. So the first, I'd say, is kind of cliche, but it's Franz Kafka's The Trial. And I say this is a cliche because it is kind of one of the canonical books within the field of law and literature that I work. There'd be hundreds, if not thousands, of different articles that have analyzed this book, looked at this book. But the reason I keep coming back to it, I keep reading it to myself, is that it's this masterful study of some of the central questions within jurisprudence. So questions around what is law, what is the authority of law, what does it mean to be a subject of the law. So that's one that I keep returning to, a really rich jurisprudential study as well as a literary work. The second one is a film. So this would be Rashomon, a 1950 film by the legendary Japanese director Akira Kurosawa. And again, so it's a legal film in a sense, so it's based around a trial as well, and dealing with the issues of testimony, of evidence before a trial. And there are 4 different characters in this trial who are giving evidence about a crime. The film really problematizes the idea of objective truth. It helps you think about the ways in which truth within a legal process is really constructed through that legal process. So you might talk about a legal truth rather than some sort of objective, essential truth, if you like. So a really interesting study of that and the problematization of that. And then I think the final one is on Australia. So it's a book by Alexis Wright called Carpentaria. It is about life in far north Australia, up in the sort of Gulf of Carpentaria. It is from the perspective of a number of different Indigenous characters, and I think for anyone who is interested in reading a book about Australia, this is the one I'd really recommend first, right? To get that perspective on Australia, on not only on sort of the settler colony as well as sort of First Nations, Indigenous perspectives on life in the country. I'd recommend that book first, absolutely.